So, what happens when a homeowner gets fed up and decides to fight their HOA? I'm not talking about angry emails. I'm talking about a full-on legal petition. Well, we're about to see exactly that. Let's dive into this case study of one person who took on the rules and find out what happened. All right, so on one side, you've got the homeowner, Brian Sopatyk, and on the other, the Xanadu Lake Resort Condominium Association. Yep, his HOA. It's a classic neighborhood showdown, right? And this one, it went all the way to a judge. Okay, here's how we're going to break this down. First, we'll look at the homeowner's 3 main complaints. Then we'll tackle each one: the screen doors, the pet policy, and this interesting fee. And then the part you're waiting for, the judge's final verdict. So, how did this whole thing even kick off? Well, it all started with a formal petition. The homeowner laid out a really simple but very serious accusation that the HOA was flat out not following its own rulebook. And you know what? This thing moved fast. The petition was filed at the end of June 2021. By September, just a few months later, both sides were in a hearing, presenting their evidence, and then, boom, by November 1st, the final decision was in. Now, this entire case really boils down to one single crucial document, the CC&Rs. You can think of it as the community's constitution. It's the official rulebook, right? It covers everything from paint colors to pet policies, all the stuff meant to keep property values up and make everything look uniform. Every single issue we're about to talk about comes down to how you read this document. And Mr. Sopatyk's petition, it wasn't just about one little thing. Nope. He had 3 separate allegations. He was saying the HOA was wrong on screen doors, wrong on its pet policy, and wrong on a fee they were charging for the community sign. Basically, he was challenging the HOA's authority on 3 different fronts. Okay, first up, the battle over screen doors. Now, I know it might sound like a pretty small thing to fight over, but you know how it is with HOAs. The whole goal is aesthetic consistency. So those small details, they are everything. So you look at the language in the CC&Rs and it seems, well, incredibly clear. It literally says that screen doors may not be constructed, erected, or maintained. End of story. I mean, that's about as unambiguous as it gets, right? So the homeowner's argument was super simple. Hey, you're ignoring a clear rule. But the HOA came back and said, hold on, our architectural committee has the authority to approve these things. And this right here, this is a classic showdown, the written rule versus a committee's power to make a judgment call. So that's the real conflict, isn't it? A clear written rule on one hand and a committee claiming it has authority on the other. So who was right? Whose interpretation was the correct one? We're going to find out what the judge said soon, but first let's move on to complaint number 2. And this next issue, oh boy, this is one that always gets people fired up. Pets. Specifically, could the HOA get away with a blanket no pets allowed policy? So once again, we've got to go back to the rulebook. The CC&Rs say that animals are not allowed without the express permission of the board. And that little phrase right at the end, that's the key to this whole argument. So the homeowner's take was that this rule implies that the board should at least have to consider requests, right? That a total ban isn't fair. But the HOA's defense was pretty slick. They said, look, the rule gives us the option to grant permission. It doesn't say we have to. And their policy? Just never say yes to anyone. So the big question for the judge was this. If a rule allows for exceptions, does that mean you actually have to consider them? Or can you just decide you're never, ever going to make one? Did the HOA really have the right to enforce such a strict no-pet policy? All right, let's get to the third and final complaint. And this one, well, this one is all about money. It's all about a special fee the HOA was charging to fix up the community's big marquee sign. And no surprise, the CC&Rs had a specific rule for exactly this kind of thing. It says that a reserve fund, which is paid for by everyone's regular dues, has to be used for repairing common areas. You know, like a marquee. So the homeowner argued, hey, this $50 a month fee is an illegal special assessment. That money should come from the reserve fund we all pay into. But the HOA, they had a pretty clever defense. They claimed it wasn't an assessment at all. They called it a rental fee for any businesses that wanted to advertise on the sign. I mean, this just perfectly shows the kind of legal gymnastics that go on, right? The whole argument hinged on what you decided to call that $50 charge. So what was it, an illegal assessment or a fair rental fee? And that brings us to the final act. The evidence is in, all the arguments have been made. It's finally time to see how the judge ruled on these three totally different complaints. Okay, so here's the final scorecard. For the screen doors, that was a win for the homeowner. The judge basically said the rules are the rules, and the text was crystal clear. But for the pet policy, that was a win for the HOA. The judge agreed the board had the right to deny all the requests. But then, on the marquee fee, the homeowner won again. The judge saw right through that rental fee idea and called it what it was, a special assessment in disguise, just a way to get around the rules. So, bottom line, a 2-to-1 victory for the homeowner. And that victory? It came with a nice little price tag for the HOA. Because the homeowner won on 2 out of the 3 issues, the judge ordered the HOA to pay him back his $1,000 filing fee. But here's the really crucial part. This ruling had teeth. It wasn't just about the money. The judge issued a direct order. He told the HOA they had to start following their own rules about screen doors and about how they pay for common area repairs. It was basically a command to follow the rulebook from now on. You know, this case is just a perfect example of how much the written rules actually matter. It shows that one person who really knows the rulebook can successfully challenge their association. Which, of course, leaves us with one final question to chew on. After hearing all this, what rules in your community might be worth taking a second look at?